That should be in your employee handbook, and it should be in your letter informing of your decision on the leave request and how everything works. So let's move ahead, and so if there are more questions on the chart, we can come back to it. But this was really meant as an overview sheet to be helpful. All right. So now this may be a well-informed group, but and when I planned this program, I was trying to think, like, what are the things that come up all the time in both unsophisticated and sophisticated employers? Things that just come up all the time. Okay, one of them is the confusion about how pregnancy and childbirth leaves work. Let me go through it, some highlights quickly, and then you'll let me know if there's more you want to talk about this. So now I'm focusing on companies that are 50 or more employees where FMLA and CFRA apply. Okay, so you know, I hope, that in your letter that goes out permitting leave for bonding, at least, right? Because FMLA, CFRA is for the employee's own condition or serious medical condition of a close family member, including baby bonding or medical. You should have in your letter that says we're counting this as FMLA and CFRA leave, so your bonding leave. And the reason you need to say that is that the laws require that you tell the employee when you're counting that. So I had a situation very recently where I'll just say the employer was right on everything, did everything by the book, but what they hadn't done is given notice that they were counting the bonding part of the leave under FMLA and CFRA, and so the employee had another right. It turned out they didn't realize it. We figured it out, and they hadn't raised that, and we figured out a way to resolve the matter. But the employee still had a right to take FMLA and CFRA yet again, because the employer hadn't given that notice saying we're counting it. So when in your notice to the employee of leave, it's important to say what kind of leave it is and what it's counting against. Because you'd hate to think, we'll go through these other things, you'd hate to think that, okay, I went through all this time, we were good folks, we gave time for bonding, we did our requirement under the disability part, and now the employee wants another 3 months of protected leave, and if you hadn't given the notice that it was being counted, it's as if they didn't take it. And there's a couple clients I've seen stub their toe on that.
So this is when they're leaving for pregnancy, correct?
The part that applies to bonding. Okay, so FMLA CFRA is for bonding. We talked about parental leave. Okay, so that's OR in the smaller companies. All right, PDL, pregnancy disability leave, it's in the chart here. It's counted separately and it runs consecutively with CFRA. So it's a quirk, and just think of it that pregnancy disability leave and CFRA are California creatures, and so they run separately. Okay, so that means that somebody, if the mother has her own medical condition related to the pregnancy, physician certifies it. You know that you've seen these letters. If the physician says that she needs the time away due to her own disability related to the childbirth, that there's up to a 4-month unpaid leave that can apply that's separate and apart from the bonding part with the child. So that means that you could have 12 weeks. I'll back up because sometimes it happens, and most often happens in this order. PDL would start, usually happens in that sequence, right? PDL starts up to some point. And then the question is, when would the bonding part start? And it may or may not start depending on when the mother's disability has concluded. It can be, I don't see it, employers mess up there too often, because usually the practical answer is, if the doctor says that the mom needs 4 months, she's going to get 4 months. And a common theme throughout is, please don't, none of us, even if we think we have knowledge, medical knowledge, please don't substitute your judgment for that of the doctors or physicians. If you think it's a fraudulent certification of some kind, there are ways, not easy, there are ways to try to deal with that. But I hear from clients constantly, oh, I'm not sure if I could believe that, you know, oh, the doctor just wrote a note, there's no detail, there's no this. You want to get the facts that you're entitled to, but trying to substitute your judgment on whether you believe is not a recipe for a good thing. So pregnancy disability leave, we talked about disability due to pregnancy, could be during or post pregnancy. So let's say somebody has taken their 4 months of disability, pregnancy disability. They've been away for bonding, okay, because it's the bonding. But then the mother says, I need more time, not for bonding, but my doctor says I've got some complication that didn't go away. Okay, now it's a disability evaluation, and it can, even for a good-natured employer, it could be, are you kidding me? Seriously? We've just been managing without this person and we want them back? They're really good and we want them back. Are you kidding me? We got to do this again? Or, I'm not sure this person's ever going to come back. I mean, that's a common reaction. It's not a nice reaction, but it's a common reaction. You know, this person's never coming back. Why are we doing this? You still got to go through the boxes, because one of the few things I can say that I hate is handing an employee a claim. I hate that. I know you do too. So if you get a request for further leave and it's on a medical basis, you're going to process it like the other stuff didn't happen, and you're going to say, okay, I want to see the medical certification, and I'm going to have an interactive process, and I'm going to find out what the reasonable accommodation may be, and you'll go through that. So, concept in the employment law. Whenever there's regulation under different schemes, federal, we're used to the federal state, right? So if there's something a little more generous to the employee under state law, then they're going to get the benefit of that law. In the paid sick leave area, there are a number of cities and municipalities that have come up with benefits that are better than what the state requires. And so this would be another layer of that whatever, so we can go over the California rule, but follow the local ordinance if it provides greater employee rights. So we're in the city of LA here. Now some of you might be in Ventura County. There's no ordinance that I'm aware of there, so it would be the state law. But in LA, city and county, there's paid sick leave law, and it's better than what the state provides. And so if you have locations that are in different parts of the state, it's not too hard. Look online. You'll find out where the local ordinances are. You know, City of Santa Monica has one, and some of them are pretty tough. That they say, you know, if you work 2 hours on average, you work 2 hours in our jurisdiction, then you've got to provide paid sick leave at their accrual rates. And so when you're looking at that, sorry, I'm giving you so much homework, but when you're looking at that and you're planning, you've got all these different things potentially. I think the common denominator principle is usually better. You would say, okay, what's the jurisdiction that provides the best benefit to the employee, and what would that look like if we applied it across the board? What would it cost us? Do a model of that. And then you're going to balance that model against your time of administration and of somebody keeping track of what the accruals are of which employees work where. So if you don't have, I'm not seeing a lot of reaction here, so maybe you don't have a lot of different locations and it'll be easier for you. Yes?
So in the case of a remote employee, it would be based on wherever their site is, wherever they reside.
Right,
Okay.
right.
So if you just had a PTO policy that exceeded any city that they were in, then that would cover it, right?
It should. Or I'm going to say a paid sick leave policy would. PTO would need, the general rule is that it needs to meet or exceed what they'd get in the paid sick leave anyway. So sometimes PTO, it's easier because it's ease of administration. The employee tells you, the reason for the out isn't as important. But you probably also know that sometimes it can cost you. You get the ease, again, administration versus cost. It can cost you on an exit because if you don't call it sick, you have to pay it out on termination. If it's sick accrual, all these laws say you can roll over a certain amount, but you don't take it with you. So there are more companies that are larger ones where the numbers start adding up, and they know what their turnover rate is, and they know what their rates. They can model it pretty easily. There's more companies that are separating it out. So, state. So, is everybody in the city of LA here? Who's not in the city of LA?
LA City is different than LA County, right? So like this would be LA County, not LA City.
Well, this is LA City. So Woodland Hills is not an incorporated
So like
city.
Calabasas would be, Calabasas is incorporated, so
Right.
they're still LA County.
Right.
versus LA City.
Right, so it doesn't apply to LA County, right?
Right. So, but there is a paid sick leave for LA County.
Yeah.
So I'm going to go to the city ordinance for LA, and this stuff, it's very. If a simple Google search will find the links. And also, I forgot to mention, if you want the slides, I'm happy to give them to you. Send me an email, and I'll email it to you. So, but in LA, it's 6 days of earning. You get to roll over up to a cap of 72 hours. No payout on termination. You're required to permit use of 48 hours a year. Two things to point out here for you. One is most of our clients, even though the accounting head at some of our clients, I'm saying the decision maker, the accounting head would say, well, I want to have the smallest accrual possible, so we're going to keep track of 1 hour for every 30 worked. And some companies are set up to do that. It's easy with your people who are on time clocks. You have to, it's a little more challenging with exempt workers. You have to sort of just assume they're working a full week. So some believe that it's easier to just give the lump sum. Just give the lump sum accrual at the beginning. There's a possibility that some people are going to be calling in sick that really aren't sick. And it kind of depends on the kind of workforce and the kind of company you have. If you have a company with a lot of non-exempt workers, a big volume of non-exempt workers, that would be an instance where you're used to paying for work done, you're tracking the hours, and having an accrual system that tracks to their hours. You put it in the computer and it's done, and that would be easier. If you're a company that has a lot of exempt workers, a lump sum may be easier. It's really, again, the balance between the modeling, the math, and the ease of administration for you. Something to highlight is that the year, so all these things are within a year, and it's more complicated than this, but basically the employer picks the year, and then you got to stick with it because you need to run it consistently for your workplace. So it could be anniversary, it could be calendar year, it could be fiscal year. If it's anniversary, it's easier because you always know what the year is, but you have to have your system set up to separately account for each individual employee. And some employers, even large ones, are not set up to quite do it that way. That anniversary you're tracking, maybe for benefits purposes, it's like you put in a number once and you never have to think about it again. But this, for administration, you got to look it up and see what it is every time. Some companies will basically say, all right, we're going to front load. All right, Will informed us that he needs to be out for 7 weeks for a back surgery. He provided us with a doctor's note. We have no formal policies or process in place. He has enough vacation time to cover his pay while away, so we want to grant the leave. We have 55 employees. So putting aside the beginning of the commentary, what are the things that you see are, what do you think the biggest problem is that jumps out of here? Right, right.
FMLA would be in place because of over 50.
Right, right, but,
They don't know it apparently. Because that would be the policy.
yes, it would. So, no policies. I agree with you. That's the foundation piece. And even though a lot of companies have that foundation piece, I see usually when a claim pops up that it hasn't been reviewed. And I mentioned earlier you may feel completely comfortable and competent to update it. Great. I just think it's a modest expense to get it out to HR services firm or your company's counsel to review it, update it, and so when we review a handbook, it gives me an opportunity to ask a client questions. Well, how do you do this? And have conversations like we're doing this morning, because it usually surfaces something that may be a risk area for them, or they have a different alternative. There are, and some companies are comfortable outsourcing that, but let's say you're either company's got tighter resources, or you've got a professional in place that's pretty much got it going on, they keep up on their education. There are outside resources that you can use. So one is California Chamber of Commerce has, they're set up for employer support. They've got an online employee handbook that's pretty good. Sometimes clients, if they have an employee handbook that's way out of date, or they haven't done one, I suggest, well, go, I think it's about $200 for an online tool. Start there, produce that, and we'll work off of that as a draft, and we'll tinker with it so it works for your workplace. So it's a way to manage the cost, because attorney time can be expensive, and creating a handbook is not always cost effective, but it's effective. So you get the review part if you want to go through a resource like that. So you need the other thing is that they don't, if they had policies, they'd have a process. If they have people like you, they'd have a process. So I think there's a bunch of reasons to have a process, and these are the top ones that come to mind for me. So of course you want to comply with your law and company policy. That's the given. You want to have documentation for clarity and protection, because you would say, here are our rules, and here's how we do it, and it's clear to everybody before whatever it is the situation came up. You want to have consistency and I have all these things: administration, morale, defense of decision making. So yes, as a lawyer, I want to be able to help a client defend a decision. Why was somebody granted or not granted leave? And sure, consistency of administration. You want to have a process because it's just easier. Instead of treating everything as a one-off, it's just easier. But the part that occurs to me is in the morale category, and you could put different words on that, but I think that I see more claims at companies where employees perceive that they're not being treated fairly. I'm saying it's a perception. You can't always control the perception. And I think that when you have a reputation for handling things consistently and evenly and fairly and not favoring people for reasons other than merit and not disfavoring people for reasons other than merit, you tend to run, over time, people get the message and you run a better workplace and you have fewer claims. Now, even though the most lucrative work for lawyers is claims, like I said at the beginning, a good day for me is helping a client avoid that. So, and of course, if alleged discriminatory practices kind of comes with the territory of what you're trying to protect. Quick story, I had a client a while back, and they were a small company, and they grew to 70, 100 people pretty fast, and they kept on getting sued for different things, and there were lots of reasons for that. There were lots of reasons for that, but I went into the president of the company one day. I went to visit them when we were working on one of their litigation matters, and I said, I finally figured out why you won't let us draft an employee handbook for you. And he goes, oh yeah? What? Why? I said, because you think that if you don't write down your policies, you reserve the right to do whatever you want to do based on what's happening that day. And he sits back and he says, well, of course. All right, that eventually convinced them to get an employee handbook, in part because I had to do the work, and that's fine. But I said, okay, in this case, if you had policies, I'm not saying it would have made all the difference, but we could have avoided this amount of the expense, and we could have reduced a little bit of the risk. And I had to point that out in multiple cases, and finally the light bulb went on, because this was somebody who was highly successful in this business, and used to making, I'll just say a CEO mentality, like I'm going to make a decision, and if the decision isn't the right one, I'm going to fix it and make another decision. Okay, now that's a really great talent and needed to lead many companies, but it isn't always the best way to create a foundation for personnel practices that are legally defensible. Process, you probably all know this, but you just maybe hadn't seen it in words before. Complete a leave of absence request form. Okay, you may have one. I'm not on commission with California Chamber of Commerce, have no financial relationship with them. They have something called a labor law digest. It's not very expensive. They have all kinds of forms that are online if you subscribe to that. It's an easy way to get forms if you don't have them. And it's less expensive than having counsel do it or an HR consultant do it. And it's a good way to sort of check that against the forms you have. I'm not saying it's a perfect solution, but you could tell I'm trying to find some practical things that can help you. You say, okay, I've got all my forms, they've worked for me, I feel really good about it, but let's see what these samples look like. And I think that subscription's, it's give or take $200 or something a year. So it's an inexpensive way for you to get another look at other forms. Medical certification form. So this has multiple purposes. It's both to figure out what kind of leave there is, return to work issues, and it is a great tool and record to have, not only because most of these laws, one way or another, require you to be making a decision based on that. In the materials, I gave you some samples. So first, let me tell you what else is in the materials. There's a handout from that I found online from the Department of Fair Employment and Housing that talks about PDL, CFRA, and FMLA requirements, and I deliberately picked the page that's written to employees, so you know what they can easily find and what they know already, whether they've read your employee handbook or not. But what made me think about this is that in the certification form, there's 3 forms there for you to consider. One is one that I wrote that is deliberately simplistic to get basically what you need and looks non-confrontational. So you have a better chance that the doctor will fill it out. Because you know that most doctors they want to sign what they're going to sign. This is a simple form that is workable in small companies and large companies. Alternatively, I wanted you to see the forms that the Department of Fair Employment and Housing say are okay for them. And frankly, they're better forms than the simple one. And so look and see what's asked. And because I think that if you know what the state government in California says is okay for you to ask and get, that's a good measuring stick for you. So they have a form that's for certification of healthcare provider, and then they have a simpler form.
Montage Insurance. Our mission is to further your mission with dedication, service, and integrity while protecting your assets and giving back to our community.